Hi, my name is Diana Alvarado, and I am an attorney that volunteers for Community Lawyers Inc. And their mission is to increase legal service delivery to underserved communities. Now, I'm an attorney at BOSTA, and we're also a nonprofit organization that advocates for tenant rights. So we wanted to put out some information out there for people, that have a lot of concerns, especially during this COVID-19 situation. And so what I did was I created a list of, some bullet points, and then also I included some questions that people have asked, and maybe they can address some of your concerns. So number one is that if you're in an unlawful detainer case already, then save your rent, right? The landlord is not supposed to take your rent during the case because otherwise they need to dismiss the case. Now, if you want to stay and the landlord asks for the rent and you're in an unlawful detainer case, you if you pay it, I mean, they should dismiss the case. But also, when if you decide to do that, you're going to need to have proof of payment. So that means paying with money order, cashier's check, keep the money order stub, and then getting a receipt from the landlord is a very important piece of evidence. And then if the landlord is not accepting your rent, then just save your rent, because right now the rents aren't being forgiven. So as of now, there's nothing to forgive the rents. Some jurisdictions have given people time to pay back the rent, but there's nothing set in stone that the rents have been forgiven. So just save your rent. Number two is so the courts are closed right now, and they're not issuing any summonses unless there is some type of like public safety issue. And so the summonses aren't being issued, the court dates are getting delayed, or they're getting postponed. We had some cases that the court dates were set for the end of June, and now they're being set for end of September. We don't know if all of them will be like that, but just keep in mind court dates are getting postponed. And then which means that the sheriff's department is not evicting people, and this is because they're trying to have people comply with the stay home order. Okay, so number three is, if you're an unlawful detainer, don't move out because you lose certain defenses and you could be on the hook for the rent. Yes, and even if you move out. So it is important to consult with an attorney before you make the decision. And you shouldn't move out. Again, you shouldn't feel pressured to move out. And I'll address that in one of my questions. So then number four is don't sign anything that don't sign anything. It is especially, you know, um, crucial for you not to sign anything because you may be waiving some rights. And also, I know that a lot of people have been receiving like forms where they have to agree to do a payment plan. If you can't pay your rent during this COVID-19 situation, then you're not obligated to sign a payment plan. You shouldn't agree to something that you're not going to be able to comply with, right? So consult with an attorney. Go to Community Lawyers Inc. and then they can refer you. And then, okay, so some of the questions that I received were, what if I can't pay my rent because of COVID-19? So write a letter to the landlord just explaining that you've suffered, substantial decrease to your income because of COVID-19. It could be because you were laid off, your hours were reduced, you had to stay home because you were ill, or just your place of work closed due to the situation. So that's sufficient. I would even say you can provide like letters from your employer saying you whatever situation applies to you, because that information is not invasive, and it shows that you're this is actually real. and it's happening, right? And then another question I have is, well, what if my landlord is harassing me? So again, if the landlord is trying to pressure you into signing something or telling you you need to move out and the sheriff is gonna come, no, the sheriff is not gonna go lock you out. First if you're not even in a case, right, and you don't have an unlawful detainer, but you can't pay your rent, the landlord cannot, the sheriff will not go and lock you out. There has to be a process of an eviction filed, right, and you need to lose the case for the sheriff to actually go out there and so there's a whole process. So no, that's not true. And you can, when you respond to the landlord, do it in writing, so email or letters. Okay. Then number 3, what if I get a notice I can't understand? We'll go to an attorney, go consult with someone, make sure you don't sign anything because you don't know if you're waiving your defenses or if you're waiving your rights. So always consult with an attorney. And then number 4 is, can my landlord lock me out? No. Locking you out is a self-help that is not allowed. Okay, so I would recommend that people have, proof that they live in the unit. Obviously, if you're locked out, right, your lease, your rent receipts, all of that is going to be in the unit. So you should, if you don't have, for example, your address on your ID, then it's a good idea to scan the lease, the receipts, and then email it to yourself, so that most likely you'll always have your phone on you, so you can quickly access that and show the police when you tell them they need to let you back in. So if you have any more questions, then please feel free to reach out to Community Lawyers Inc. and I will be happy to answer any more questions that you may have. Thank you so much.